Okay, on our agenda today, we have a couple of bill hearings. Before we get into that, are there any requests for bill introductions? Okay, seeing none, we'll jump right into opening the hearing on House Bill 2116, exempting the caregiver of a child in state out-of-home placement from the child care assistance 20-hour per week work requirement. First thing, we'll have a briefing from Jesse.
Thank you, Chairwoman. Good afternoon, members of the committee. Today for House Bill 2116, the bill amends KSA 39709, which is a statute that creates different eligibility requirements for federal assistance. And under subsection B, the statute specifically creates eligibility requirements for temporary assistance for needy families. Subsection B16, capital B, states as the Secretary for Department of Children and Families shall adopt rules and regulations to determine and maintain eligibility for non-TANF child care assistance, which is also a federal assistance that the department receives, and including the requirement that all adults shall be employed for a minimum of 20 hours per week or more to receive such assistance. But there are some exceptions to that work requirement. And House Bill 2116 would add another exemption to that 20-hour per week work requirement for adults who are caretakers of a child in custody of the Secretary in out-of-home placement needing child care. That section would take effect upon publication in the statute book. I'm available for any questions.
Committee, do we have questions for Jesse? Okay. Representative Wagoner.
Yeah, Jesse. So I'm having a little bit of trouble following this. This exempts them, or this, explain again exactly this group of people who are caretakers of a child in custody of the Secretary in out-of-home placement needing child. These are like foster parents, or these are like,
Yes. So those who are receiving this child care assistance funds, they are required to work 20 hours per week in order to receive that assistance. So this bill says that foster parents or caretakers of children who are in custody of the Secretary who need child care are now eligible for that assistance without the requirement to work 20 hours a week.
Further questions? Representative Penn.
Thank you, Madam Chair. Can you hear me? Okay, great. Ma'am, does this stipulate that those adults, I'm going off of what I have as page 8, it says adults who are caretakers of a child in custody of the Secretary in out-of-home placement needing care. Does it stipulate that they are certified foster parents, or how they either maintain or ascertain said certification?
So the language of that applies to a child in custody of the Secretary. So that would be under the Secretary's purview of placement. So that would be a child in which the Secretary has placed that child with that caretaker.
Thank you, Madam Chair. I'll hold further comment.
Okay, further questions for Jesse? Okay, we'll open up with the proponents. And first up, we have Sandra Kimmons, Director of Economic and Employment Services at DCF. And we are expecting her remotely.
Thank you, Chair. I am here. The audio is by phone, so please let me know if you cannot hear me.
We can hear you just fine.
Super. Thank you so much, Chair and Committee. I am Sandra Kimmons, the Director of Economic and Employment Services at DCF. As you are aware, DCF does have a child care subsidy program that is funded by federal child care funds. There is currently a provision in our state law that those requesting child care assistance to support their employment for the hours they're working, they would need to work 20 hours a week. The law does have a few exceptions, such as teenagers in high school getting their high school diploma, and then individuals that are in our agency's employment services program. We are aiding them in seeking employment. This suggested change is actually just a very small technical one that we are presenting to see if there's any interest in adding this additional situation to the exception. In the summer and fall of 2019, the agency moved child care payments for foster caregivers or foster parents that were working from being paid with foster care funds in that program to utilizing the federal child care subsidy funds. Then later, the agency began discussing if using these federal funds for these foster caregivers who are working 1 to 19 hours a week, not the 20, if that was out of sync with this 20-hour work requirement in the law. Discussion was this social service child care, or is this really child care to support employment, although it's the employment of the foster caregivers? So that's why we're bringing this change to you today. We do want you to be aware if the federal child care subsidy funds are not used for these child care payments, they would be paid out of state general funds. Currently, we estimate that's approximately 42 children, and it would be right at $160,000 a year. So DCF is asking for the support of House Bill 2116. It does seem like a win-win. It would save the SGF and pay for this child care need out of the federal funds. And then also it would be a support for the foster caregivers who are obviously meeting such a valuable need for us in Kansas. Thank you. That is my testimony, and I will remain available for questions. Thanks again.
Ms. Kimmons is the only oral testimony that we have, so we'll open it up for questions. Are there questions? Okay. Thank you, Ms. Kimmons.
Thank you so much.
So you have, oh, I was going to ask, is everybody doing okay with getting the bills and the fiscal note and the testimony with the email the day of? Okay, good. Then we have written only testimony from Rachel Marsh of Children's Alliance of Kansas. So you can read that when you have an opportunity. I show no neutral testimony and no opponent testimony on this bill. So at this time, I'll close the hearing on House Bill 2116. Okay, we'll open the hearing on House Bill 2149, and we'll look to Jesse for an overview.
Thank you, Madam Chair, members of the committee. For the second bill today, we have House Bill 2149. It would amend a statute related to the licensure of child care facilities overseen by the Secretary of the Department for Children and Families. So KSA 65516 establishes the restrictions on persons who maintain a child care facility if there are certain persons who reside, work, or regularly volunteer at that facility. So the new bill has a new subsection K, which permits the Secretary of the Department for Children and Families to exempt a child care facility who is licensed or applying for a license that has certain persons who reside, work, or regularly volunteer at the facility that would otherwise not be permitted. The Secretary may exempt child care facilities where any person who resides, works, or regularly volunteers at the facility has been convicted of a crime classified as a person felony in Kansas, in any other state or the federal government, has been convicted of acts involving controlled substances, violated provisions of the Uniform Controlled Substance Act before 2009, or any similar statute of another state or federal government, has been convicted of any attempt to commit or conspiracy to commit any crimes against persons, crimes affecting family, relationships, and children, sex offenses, and other certain offenses, or similar statutes of any other state or the federal government. Also, persons who have been convicted of promoting obscenity to minors in similar statutes or other states and federal government, has been convicted of arson or aggravated arson in the similar statutes of other states and the federal government, has been adjudicated as a juvenile offender for a crime against persons that would have otherwise been a felony if committed by an adult for certain crimes listed in that section, or any other similar statutes of any other state or federal government, or has an infectious or contagious disease. So the Secretary determines if this exemption is in the best interest of the child in the custody of the Secretary, who is or will be under the care of the child care facility, and that person does not present a safety concern, then the Secretary may grant the exception for the facility to be licensed and have such persons. This section would take effect upon publication in the statute book. I'm available for questions regarding House Bill 2149.
Committee, do we have questions for Jesse? Representative Neighbor.
Thank you, Madam Chair. So, Jesse, this would permit those that have had interactions that were inappropriate to volunteer and work in these child care settings?
It would permit those who have been convicted of those listed crimes to reside, work, or regular volunteer at the facility and remain licensed by the Department for Children and Families.
Do you have what the rationale for that was? It may not be your purview, it may be somebody testifying.
Yes, the conferees would be able to answer
Okay.
that question.
Thank you very much. Thank you, Madam Chair.
Further questions? Representative Wagoner.
Is there any limit on the number of people? If you had like 5 employees, could all 5 of them have been convicted of a crime and it would not be a problem?
I am not aware of a number regarding the limitations on that.
Okay, that answers my question.
Yes. Thank you.
Okay, thank you, Jesse. We will open the hearing with the proponents. And first up, we have Jonathan Stahl, a KVC foster parent. We have him in person. Welcome to our committee. Come up here. Make sure you push the button there and the light comes on.
There we go.
There.
Good.
Thank you.
Good. Good afternoon. My name is Jonathan Stahl. My wife and I have been fostering kids for about a decade and specialize with difficult teens. Today, I'm here to tell you the story of our family. Like every story, ours has a hero and his name's Alex, and I'm here for him today. When my wife and I started fostering, we intended to foster boys 0 to 6. We had determined that teens, especially teen boys, were scary. After a year of fostering 2 precious boys who went home to be with their dad, a month later, we accepted 2 more boys. A month after that, I was sitting in my living room relaxing, having put the boys to bed, and got a call about a 13-year-old named Alex. My friend told me that Alex was a tough kid, but he was perfect for us, and without hesitation, something that surprised even me, I said yes. The next day, I watched Alex arrive through the window and noticed he had an ankle monitoring device on him. I was immediately nervous that I had gotten myself into something over my head. What if this kid broke things in my house or brought in drugs or was involved with a gang or endangered our family? When I opened the door, his shy, goofy grin melted all those fears away from me. This was a kid that needed a home, and we were all in to give him one. Over the next few months, Alex grew in our family. We watched him nest into our room, make it his own. 3 months later, we got a call from the same friend that called us about Alex. She said there was another kid named Zay who needed a home. Zay was 15 and the same age as Alex in the same group home that Alex had been in. Zay had been in 50 different placements before he was placed into our home and had suffered 2 failed adoptions. I told her that Alex was very attached to his room, and I'm not sure that Alex would go for it. But as I sat down Alex and talked to him and mentioned Zay, Alex interrupted me saying, Zay needs to come live here. He can share my room. He said this kid deserves a home. And 2 days later, Zay was a member of our family. Trauma's hard. Trauma behaviors are hard. In addressing his own trauma, Alex would self-medicate. He experimented with drugs, snuck out of the house, and challenged us as parents in ways we'd never been challenged before. Zay would have PTSD-triggered meltdowns where he would jump out of cars when we parked at stopping lights, tear up our house, put holes in the walls, and run away from the school. We watched our 2 sons struggle, succeed, and then struggle more. Throughout this, Alex and Zay had become brothers. They picked each other up when they were down, they prayed for each other, and they defended each other at all costs. When our son Jude was born, Alex and Zay were so proud. They were the best big brothers. Alex would hold Jude nonstop, and Zay would sing him songs. They both bragged about their little brother wherever they went. Over the years, our struggles continued and our successes continued. By the end of the year, Zay's behavioral teacher, a teacher of 20 years, said Zay had showed more growth than any student she'd ever seen. We were both proud of him. At this point, Alex did not have any visits with his family in 6 months and had not seen them in a little over a year. Alex had a routine court hearing, and it was 2 hours away, so I opted not to go as most things were not decided then. At the court hearing, the judge told Alex that Alex was a waste of our time, that Alex deserved to be in jail, and that he hoped Alex would end up there. The judge then sent Alex back to his parents, to his bio parents, without any warning. I was crushed. Alex argued with the judge to allow him to come back to us and for us to say goodbye for one day, and the judge finally agreed. We spent one last day together. It was the hardest day of my life. Zay was devastated. Our younger 2 were devastated, and Alex was numb. He hugged us goodbye and went out the door to his new old home. The next 3 weeks were hard. I missed Alex deeply. You see, somewhere over that year, Alex had become my son in my heart. While training to teach foster licensing classes on trauma, 3 weeks after Alex had left, I got a call from his mom, and he had gotten into a fight. She was scared about who he was hanging out with and had not put him on his insurance yet. She asked if I could pay for the dental bills, and I agreed. He came to our house for a weekend visit to get his dental surgery done, and 2 minutes after they pulled out of the driveway, I got a phone call from Alex's mom. She told me that she felt he was better off with us, that they could not raise him, that they wanted to sign over guardianship to us, and she asked me to tell him that for her. Guardianship meant several things to us compared to being his foster parents. We would get no money from the state. He would be on our insurance, and most of the supports that we had for free in the past would be gone. We would be responsible for him in every way. Without hesitation, we said yes. This wasn't about the money. This was about our kid, and he needed help. I would not let him go somewhere where people were unwilling to raise him and unwilling to put the effort into him. You see, Alex takes a lot of work as a parent. He takes high investment, late night talks, lots of hugs, lots of emotional energy, but he is worth it. The next 2 years of being his guardians were the hardest and most rewarding years of our life. You see, trauma doesn't disappear when kids are given permanency. Alex went to rehab in Florida twice, both of which we paid for, picked up some charges, struggled, fell, picked himself back up, and kept growing. One of the times that Alex had been using, he attempted to drive, and I attempted to take the keys away from him. I ended up getting a concussion in the struggle, and Alex was charged with a juvenile felony. Alex and Zay have caused us to fall in love with teenagers and to take hard teenagers. We've had many, many placements in between, and we knew we wanted to be there for them. So this did not faze us. During the time, we had taken another teenager full time named Day. He was from a rough background, and I was worried Alex and Zay would not accept him. The first night I heard them whispering in their room, and I immediately feared they were planning to do something like sneak out or get drugs. As I leaned in to listen to the door, I heard Alex praying with him, saying, "Dear God, thank you for our new brother. I know it's scary now, but help him know that this is his family and that he is safe." Throughout the years, we've become the house that KBC goes to place difficult teen boys. We've had hard kids. We've had kids with gun charges, with armed robbery charges, gang involvement. We've had a kid who was a drug dealer and had multiple guns hidden on him. We fearlessly take these kids because no one else will and because we believe they deserve a chance. It breaks our hearts to know what would happen to Alex or Zay had they grown up, bouncing from more houses to more houses. DCF has thanked us profusely in taking these kids, as well as for giving Alex permanency in a safe home. After a long negotiating in court, Alex finally got his charges and started working towards his future. He is now clean and sober. It was then a few weeks ago, right before turning in our renewal paperwork, that Alex's background check was turned in, and we got a letter from DCF saying that we had 5 days to send Alex somewhere else or to send the other boys somewhere else. Since then, we've been asked to take multiple kids with much worse charges than Alex, which is perfectly legal because they are still in foster care. The only difference between Alex and these kids that we take every day is that we are his guardians and he is not in foster care. Had his judge done the right thing to keep him in care, we would be labeled heroes and lauded by DCF for keeping him in his house, and now we are giving the choice of sending him away or a 17-year-old son away that is also in foster care. We've been asked to choose whether to send one or the other away. I fully believe that neither of these boys can handle the trauma of being taken from our home. Both call us their parents. Both call everyone in the house their brothers. We've been forced to temporarily find arrangements for Alex to be with a family friend until we can get this issue fixed. We've been told that there's no exception, no option, and no way to fight this. Alex has been sober, worked hard to get his diploma, and have a plan for his life. I do not believe that without this family he will succeed. I fear that he will become depressed and fall back into drugs or not finish school. I am heartbroken for my son, but I'm also angry. Angry that as foster parents, we are constantly impressed upon to give children permanency through adoption, that this is, after all, the best outcome for them. When I teach licensing classes, I speak often about the importance of adopting teens and giving them permanent homes. Adoption doesn't absolve trauma. Kids that came from foster care will still struggle. They will still get charges. They will still exhibit this trauma. It is my fear that parents will not adopt teens if they know that the second they do, they will be punished when those teens struggle by not allowing them to keep the other kids in their house. Alex instantly went from a kid who everyone was begging us to keep through incentive, through raising his rates, through praise, through extra services, to a kid that was too dangerous to be in our house. Never mind that we are still being asked to take kids, even yesterday, in care that have far worse charges than he does. I am here today to ask you to change this law so that my family can be back together, so that foster parents are encouraged to adopt hard kids, not punished when we do. I'm here to ask you to change this law so that when I tell my teens that we are in it forever, no matter what, that I'm not lying. I'm asking you to change it for the teens who need to be adopted, that don't have parents, without the parents fearing that these teens will mess up their chance to continue to keep the other kids in their home. No parent should have to choose between an Alex or a Zay. These boys have become our whole world. They are the reason we continue to take hard kids, the reason why we believe every child deserves a family that loves them, and the reason why us and other foster parents that take hard teens are helping kids not be stacked in the offices that have charges sitting there without anyone to adopt them or take them in. Alex has changed our lives. I wouldn't be the parent, friend, brother, teacher, or husband I am now without Alex. He's brought to our family more than we have given him, and we can't imagine our lives without being his parents. He's my greatest support, my greatest encourager. He's the best big brother. He's the one that chooses brothers out when they use drugs or sneak out or are disrespectful. Alex is a hero to our family. We are asking you to be a hero to him. Thanks.
Thank you. Committee will hold questions till all of the proponents have gone. And I forgot to announce that because we have so many conferees today that they've been asked to keep their testimony between 5 and 7 minutes. When I'm saying this mostly for those that are remote now, because all the rest of them are, but when you get to 6 minutes, I'll give you a 1-minute warning, and then we'll need to wrap up at and finish up by 7 minutes. So next up, we have Scott Hendricks, Director of Permanency at DCF.
Yes. Thank you, Madam Chair and members of the committee. I appreciate the opportunity to speak with you this afternoon. I want to start by saying that DCF has requested and introduced House Bill 2149 in an effort to remove barriers for families who want to serve as licensed foster caregivers, much like was just testified to. And we also want to increase supports for children and families throughout the foster care system. In writing this bill, we wanted to make sure that, or the draft, we wanted to make sure that we covered all bases, but we are definitely willing to go back and amend language to omit any sex offenses that were mentioned at the beginning. That was not the intent, and we're definitely willing to do that. Barriers exist currently for licensees or potential licensees in reference to KSA 65-516 regarding criminal offenses or prohibited persons. There's very strict language in the statute that indicates no person may reside, work, or volunteer in a facility that is licensed. Additionally, there is no allowance for an exception to the statute. There is no appeal process. And there's also no statute of limitations within the statute for those specified convictions. So the only recourse that a family is left with is a legal expungement. That can be very costly and time consuming, which is not really conducive to the family or the child or children who are needing placed. What House Bill 2149 would allow for is the Secretary of DCF the discretion to grant an exception to specific criminal offenses or in specific cases where it has been identified that there are no safety concerns and it is in the best interest of the child to remain in that placement or be in that placement. These types of determinations are conducted on a daily basis at DCF, so this would not be a new concept or process. But again, this would not be a blanket exception for a certain facility or anything like that. It would be a specific case-by-case basis before any such exemption would be granted. To offer a bit of a history and context behind this, it was the Executive Reorganization 43 enacted in 2015, which moved licensing of foster care 24-hour facilities from the Department of Health and Environment over to DCF. DCF is now responsible for all licensing aspects of those facilities, including preliminary and ongoing criminal history background checks per KSA 65-516. And within that statute, there are a wide range of offenses included. I mean, you can go all the way back to juvenile, non-person offenses, all the way to felonious charges, convictions, misdemeanors, etc. Again, no statute of limitations, nothing that says that a child or that a person may be eligible in X amount of years. There's no appeal and there's no exception. As the licensing entity, we currently have no authority to grant exceptions to any provisions within 65-516. Some of the specific problems by this lack of flexibility, it limits our licensing and placement options for kinship home. A substantial number of kinship providers will not be eligible for licensing and the added benefits and resources of licensing because of the statute. It limits relative homes from becoming licensed as well. Relative placements, which we have a big initiative to keep children in with relatives, they have an option to become licensed if they so choose. Some, again, may not be eligible. We know of because of this statute. So you might have mom, grandma, or aunt and uncle caring for a loved one and might need some added assistance, but they are not eligible to get it currently with the statute. It limits the ability of some foster or adoptive parents to maintain their license, as was just testified to. We've had homes have to relinquish their license because someone moves into their home with a prohibited offense. It may be an adopted child. It may be a child of their own, or in some cases, it might be a parent or grandparent that they want to care for. So those families are left making those tough decisions. It also limits the employment pool for congregate care settings, which have to meet various specified ratios. And we've had instances where there's impact on the interstate compact for placement of children. In other words, a child from another state in the custody of another state, they might want to place in Kansas with a kinship type provider. If the sending state requires the home be licensed, there has been problems in that area too. What this legislation would do, if the secretary was granted the authority to issue an exception, it would allow for more placement options for children in custody of the secretary. That would increase the capacity, supports, and resources for all home type settings. It would allow for certain family units to remain intact while providing care for children in custody. It will assist the department, with meeting established federal outcomes and other requirements. Over recent years, DCS has strived to take a more common sense approach to licensing. We feel like this bill aligns with that approach. And we also firmly believe that it will assist us in improving our placement stability efforts by decreasing child moves and advance our ongoing kinship or kin first approach in Kansas. So of note, there is a similar process in the state. The KDADS, the Department for Aging and Disability, has a waiver option for individuals with criminal history for their purposes of employment in facilities and agencies they oversee. So we respectfully ask for your support of House Bill 2149. That concludes my testimony, so I'll gladly take any questions that you might have.
Okay, thank you. We're gonna hold all questions for the proponents till all the proponents have spoken. So next up we have Jim Rosendale, St. Francis foster parent, joining us remotely.
Hello, thank you, Madam Chair and members of the committee. My name is James Rosendale. I live in Hayesville, Kansas. I have been a foster parent with my wife for the last 4 years, and I have a similar story to the first gentleman that spoke. My hero is named Cameron. Cameron was the second child placed in our home on a permanent basis. First was placed in September of 2017. Cameron and another boy were placed in our home in December of 2017. We then were placed a young girl in July of 2018 who was paraplegic and diabetic and in need of a great deal of special care. The kids moved in at that point, and we almost immediately began working to adopt all 4 of those children. It took us until February of 2019 to adopt our first boy. It was April of 2020 before we were able to adopt the next 2 boys, and Cameron was one of those 2 boys that we adopted. Between Cameron's adoption and our little girl's adoption, of course, we had to do background checks due to the boys' age and in accordance with the law, and also had to go to the hospital with our little girl for yet another hospitalization. Upon returning home from that hospitalization late on a Friday evening, we opened up our mail and found a letter from DCF stating, as was previously testified, we had 5 days from the date of the letter, which was actually 4 days into it, that we had 5 days either to remove the boy that we had just adopted or the little girl that we were fighting so desperately for. That began a series of phone calls. I immediately tried to call DCF, which of course they were already out of the office. I instantly tried to call my worker who was not on call. I then called the St. Francis on-call line and got somebody who knew our home very well And that began both a weekend and the next week, very, very harrowing calls and discussions around what we could do. Due to the work of my worker and someone in DCF that I still do not know who, the decision was made, since we were just simply days away from our little girl's adoption, to not move either of the children out and to finalize the adoption. We were allowed to do so, and then subsequently had to close our license because with the boy in our home, we could no longer be foster parents. I found this a great tragedy for my children, who I love very much and fight for nearly every day, one thing or another. It was a great tragedy for the system that tries desperately to care for these most vulnerable children. And I think it was a great tragedy for our state. Our kids are adopted. Our story is, for the most part, over. But this bill must be passed to take care of foster homes, like you've already heard for, to take care of our own foster home, and the others that will probably come to fruition along the way. It was, the kids had been in our home for 2.5 years together before anything was ever said. Cameron was the same boy that moved in December of 2017 as he was midsummer of 2020, but suddenly he became unacceptable to have in the home with my other children or with us. This must change, and I ask for the committee's full support behind House Bill 2149 so that our home and other homes like us can be protected of this kind of a tragedy. That concludes my testimony, and I would be available for questions. Thank you.
Next up, we have Jeanette Owens from DECA.
Good afternoon, Madam Chair and members of the committee. Can you hear me okay?
We can.
Okay, great. Thank you for your time today. My name is Jeanette Owens, and I'm the Chief Child Welfare Officer at DECA. At DECA, we've served Kansas communities, families, and children for the past 46 years. We provide child welfare programs, including our Child Placing Agency and Family Preservation Services, as well as many additional programs that I provided in my written testimony. The services that we provide across multiple systems highlights gaps and areas of potential connection that can elevate care, services, and outcomes. We believe that House Bill 2149 is important in addressing a system gap that prevents timely permanency for some Kansas children in foster care. As you've heard with previous testimony, there are specific areas of KSA 65-516 that I will highlight today, of 2 of those areas that create barriers to permanency for children. The first barrier is when an individual seeking to provide kinship or foster care placement has been prohibited to become a licensed home. While we understand the need for prohibited offenses, we also recognize there are circumstances when the discretion to grant a license could be in the best interest of a child, specifically when that licensing home would not present a safety concern. I'd like to share an example of this current barrier. At the beginning of the pandemic, we had a family contact us that had 2 high-needs kinship placements in their home. The family shared they were struggling to meet the high-level needs of the children they were supporting. We immediately started working with the family to get them licensed so they could get additional supports and training, financial services, as well as other resources, including advocacy for them as they took care of these 2 teenagers. The kinship father disclosed that he had a potential concern in his background records, and unfortunately, after working with his family for multiple months, we were notified that the kinship foster was prohibited from becoming a foster parent. The charges were from 20 years prior, but DECA had to discontinue working with the family. A few months later, the family reached out to us to share they were unable to maintain the placement of the boys. While we're not sure that our supports would have prevented the disruption to the children, we do know that a CPA advocating for the youth's needs does significantly reduce disruption. The second barrier to KSA 65-516 that I'd like to discuss today, which is similar to what you've heard from Jim and Jonathan, is when a youth in a foster home that has a juvenile offense turns 18 years of age and becomes prohibited from being in the very foster home that he or she was safely in months or years prior to turning 18. I'd like to share 2 examples of how that's impacted foster families and children we care for. We had a wonderful foster home that cared for teenage girls for over 10 years. They often took teens that had multiple charges, including their last 3 placements that all had felony drug charges after being found in the possession of drugs. The foster parents worked with the children and maintained their placement until the girls turned 18. Unfortunately, after the girls aged out, their offenses were now deemed as prohibited, and thus the foster family could no longer provide the supports the girls needed, such as being able to come home to stay the night or to be around the other teen girls in the foster home. That meant that these girls were not even able to come home for the holiday celebrations. Another similar example is an amazing foster father that we had that was able to take teenage males that had been charged with sex offenses. The foster dad was willing to take some of the most difficult youth to find homes for and help them specifically complete court orders and requirements. After many years of positively impacting so many youth's lives, this foster dad had to decide between caring for the 3 foster children in his home under the age of 18 or allowing the youth that was deemed a prohibited person on his 18th birthday to remain in the only home he had. Our foster dad made the decision to give the 18-year-old a home, and I'm happy to share that youth has gone to college and is doing well. Unfortunately, the foster father had to close his foster care license, and the other three teenage males then had to be in a home in other locations. To conclude today, all of the examples I've shared could be addressed by the passage of House Bill 2149. Thank you for the opportunity to share the challenges this bill would address to reduce barriers for permanencies for Kansas foster children.
Thank you, Jeanette. Rachel Marsh with Children's Alliance of Kansas.
Good afternoon. Can you hear me?
We can.
Thank you, Chair Kincannon, Vice Chair Esau, and Ranking Member Owsley, and members of the committee. My name is Rachel Marsh. I'm the CEO of the Children's Alliance of Kansas. I've appeared before you before, and there are such experts here today. I will be very brief and not go over the 7-minute limit. What I want to share with you today is that our 18-member association enthusiastically and wholeheartedly and strongly supports this bill. We see this as perhaps the most concrete and critical way that Kansas Legislature can help children in foster care in a very tangible and immediate way this session. You've heard the stories, both for the perspective of kinship families supporting children, and you've heard the stories of the youth with complex needs that need home environments that love them and don't have to choose between a foster child before they're adopted and a foster child after they're adopted. The licensing statute, it can become confusing. I want to address that. There were some important questions asked at the beginning of this. What kind of facility is this? In my opinion, if you look at this, the federal definitions of child care facility and you work it down, what that means is licensed foster homes. And so what we're talking about is that kinship families who may be able to take a child into their home, despite the 20-year-old minor charge from when they were a juvenile, cannot get licensed to do the very same work, which means that the families you might have the most concerns about are actually getting the least amount of support, which is a backwards consequence. We want all families in Kansas stepping forward to care for children who do not have safety concerns to be able to care for children with the full amount of child placing agency advocacy and with support, the financial support, the benefit support, and all the other benefits of training and ongoing assistance that you can have in foster care as a licensed foster care provider. The other piece is, I just want to reiterate that the stories that you heard earlier from the other conferees, they're not rare. They're unfortunately all too common. It's been my personal experience that when you are looking at adopting and finding permanency finally for a youth who has maybe had those juvenile justice charges or those criminal background history, we now in our current system have to stop and say, and kind of play Sophie's choice. Can we adopt this child and not disrupt the other child in the home? And we shouldn't be pitting foster children against each other in order to get adoption. So we would definitely support this. And what I would also offer and slow up my 7-minute approaching, is that this can feel like a technical bill, and it is a technical bill. There's lots of federal law, state law, and compounding technical issues. The Children's Alliance stands ready to answer any questions that any member of this committee has, to go find the research to get you the detail that you would need to be in support of this bill. Again, we all are very supportive of this, and we hope that you will keep an open mind and consider how this can help children and families in Kansas. And I would be happy to stand for questions at the appropriate time.
Okay, thank you, Rachel. Committee, I'll draw your attention to written testimony. There are 2 more foster parents, Anna Woodward and Stephanie Wooge. And then we've got Lindsay Stevenson, Vice President of Operations at KBC. So that's the proponent section. I don't show any neutral, and so we'll move on to the opponents. And first up, we have Greg Smith with Johnson County Sheriff's Office.
Madam Chair, thank you very much. Committee, happy to be here today. My name is Greg Smith, and I'm the Special Deputy for Government Affairs for the Johnson County Sheriff's Office. This is not a committee that we usually appear in. So for those of you that don't know me, I'm entering my 24th year in law enforcement. I've spent 6 years in the legislature, 1 term as a rep and 1 term as a senator. And I'm here today to represent the Johnson County Sheriff's Office, and we are in opposition to House Bill 2149. The proponents have some heartbreaking stories and a tragic and tough environment for them to be in. But HB 2149 is not the answer to that problem. The latitude that this bill would give an appointed official, not an elected official, an appointed official, is unprecedented. In our review of the Kansas statutes, we can't find one other appointed official anywhere that has this kind of power for a waiver decision. Even in the prison system, there's a prisoner review board that has to approve everything. There's no checks and balances in this system. There's nothing that says how the decision is made on whether or not it's in the best interest of the child, or if the person doesn't present a safety concern. Without some kind of validated scientific risk assessment tool, I don't think you can make that kind of statement with any certainty. I can tell you story after story of officers that have been out in the field and have dealt with people that committed crimes for years and years, and actually got to where they had some kind of friendly relationship to them. I can think of one gentleman that I came in contact with for over a 4-year period when I was on the street, and we would talk about our families, that kind of thing, even as I had to arrest him for something, until one day he decided he was going to try to kill me. I just don't think you can make that statement that you have absolute certainty what this person is going to do. The type of offenses that are listed here, it's wide open. Any person felony, that ranges from capital murder to stalking, and without exception, not one of those felonies would not put a person in danger of physical harm or death. So maybe there are some of the crimes that are listed that could conceivably be waived, but there needs to be a process in place, and not just the decision of one person deciding on how this would work. Again, we'd like to see a validated risk assessment tool used in this, which requires training on how that works and some knowledge of the criminal justice system and the court system. And as this bill is written, the Johnson County Sheriff's Office would encourage you to not pass this bill. This is not the answer to the problem that the proponents are bringing to the legislature. There is an answer, but I don't think 2149 is the way to do it, and I'd be happy to stand for questions at any time.
Thank you, and it's good to see you again. Next up, we have Ed Klump with Chiefs of Police, the Sheriff's Officer, or Sheriff's Association, and the Peace Officers Association.
Thank you, Madam Chair. My name is Ed Klump. I'm a retired career law enforcement officer, 35 years with Topeka Police Department, 2 years with Lawrence PD. I retired. I was chief of police here in Topeka, and I have been representing these three associations as a liaison between legislature and also with state agencies since my retirement. Our concern with this bill is much along the lines of what you just heard from Greg Smith. We don't have a particular problem with some level of exceptions, but what our concern is a wide breadth of latitude that's provided in this proposed bill. You heard a lot about the foster care system, but this bill is not limited to just the foster care system. If you look at the first page of the bill on line 9, it refers to a child care facility. And if you look back in KSA 65503 and look at that definition of what a child care facility is, you see that these exceptions would also apply to licensing, not just for foster homes and foster kids, but also daycare facilities and other child care facilities. Our particular concern is even higher when you talk about the employees and volunteers of those facilities over just the residents as have been described in the foster care issues that have been presented to you. So we're not opposed to any exemptions. We don't believe this process has been well thought out. We believe it opens the door too wide to some type of subjective decision making. We don't see that the department would have access to case details to fully understand the behavior that led to the convictions in a lot of these cases. There's no consideration for the severity levels of the crimes that are committed. There is no consideration whether that person is still on probation or parole for such crimes, or the length of time since the person has been released from prison, for example. And again, our concern is accelerated when you talk about employees and the volunteers and the adults that could be in these homes, some of which could have passed with some pretty serious crimes. I listed some of those crimes, and you'll note that there is a lot of crimes against children that are in this list of crimes that could be exempted. And we are very troubled by that. So just to summarize, we believe there is some way to fashion some form of exemption process. We don't believe opening the door like this is the way to do it, with a wide open slate to even exempt very serious criminal behavior by adults. And for adults who would be presenting and providing services to the children. We have less of a concern, although there is concerns, there's less of a concern when you're talking about the residents, especially residents with experience with each other where there hasn't been a problem. So with that, I will just end there and answer questions when the time is appropriate.
Hey, that I don't show any other opponent. So we'll open it up for questions, and I've got a question. Oh, I'm going to need some help here. Okay. I've got a question. Can we go back to Jesse? Jesse, are you still with us?
Yes.
So I was just wondering if this is a decision that that the secretary would make to grant an exception. Does this, if there would be something that would happen, does this open the state up to any liability?
I do not know the answer to that.
Okay, that's fine, Jesse. We could talk about it later if you want to check on that.
I will. I'll get back to you.
Okay, thanks. So let's see, Representative Helmer.
got caught up there. Thank you, Madam Chair. I was going to talk about that just a tad bit. I've been involved in some cases where this has happened. And so there is some liability put back on the state, and it's kind of a deal that they make with the state. So the first thing that I wanted to say is I've always thought there's something left out of that if this does go through. The people with disability are always left out of that. And so the people with disability, no matter how small the disability is, don't seem to have a person that is a nurse or something that's coming out and checking on them. And if they get pulled out of the home, they're just pulled out. And there's one right now that was pulled out of a real close friend's or a constituent, I want to say. And she's been out for about a year, and now she's back in up for adoption, and there was no reason. And it was almost exactly the same thing. So there's a lot to be worked on this bill before it goes through. And my question was the liability of the state also. But also, you'd have to get a lot of things down and pat about the maintenance and acceptability of what's going to be happening with the adoptive family and what's agreeable to them. I like the idea. I agree with the sheriff that there is not enough supervision about what's going on right now. And so we need to look at that to get good supervision to do this, because it could be a great program, a wonderful program, but you guys sure don't want to do this on your own. It would help us. So I would love to do it with some money and do it right and do it for the kids and be able to do it the right way with supervision. Thank you, Madam Chair.
Representative Vaughn.
Thank you, Madam Chair. I have a short series of questions just to kind of address some of the concerns that have already been raised, possibly through the amendment process. So first, I just wanted to ask Mr. Hendricks, one thing that the sheriff's mentioned was implementing a risk assessment tool to be used by the Secretary of DCF and to then train the Secretary in that risk assessment tool. Is that something that would be considered reasonable for the Secretary, or are there other ways that you are planning to determine whether the placement would be safe for the child and the public?
We're definitely open to that. We are open to any suggestions or revisions that will help this process along. So to answer your question, yes, we're open to that.
Excellent. Thank you so much. And then, let's see. Question about the definition of child care facility. I know Ms. Marsh, you brought this up as well. If that were to be redefined as foster care placement or something a little bit more narrow, would that significantly change the nature of the bill in your eyes?
I appreciate that question so much, and thank you for allowing me the opportunity to respond. My take, and I have a narrow take from my membership, focus on kinship families and youth with complex needs. So I will not speak to the need for DCF to expand this to congregate care because I did not familiarize myself with that aspect. From my perspective, where I sit, this could be very easily narrowed to eliminate the Sophie's choice between adopting like a foster child and not adopting a foster child through very clear language. And it could also be limited to in this subsection K, where a family has a relationship with a child or is a kinship placement. I think these are very easily addressed concerns that have been raised, and would be happy to work with the committee to make it narrow enough to get the committee's support.
Excellent. Thank you. That's really helpful. And then my last was for Mr. Smith. I read your testimony and appreciated your insight in terms of the different types of offenses that, could potentially be narrowed to make this a little bit more, narrow in scope and in your eyes less potentially dangerous, particularly as it relates to the personal felonies, sex offenses, and drug offenses or drug felonies. Is there a list, or is that something that you'd be able to consult on in terms of, what could be a more narrowed list for this particular purpose?
Thank you for the question. I mean, the sheriff's office would be happy to work with anybody that's bringing an amendment in the revisor's office to try to come up with something. Chief Klump's testimony basically has a list of all the different crimes, or at least the sections where those crimes are. It's quite extensive. Right off the cuff, I couldn't give you, okay, yeah, we can waiver that, or no, we can't waiver that. But I mean, we'd be happy to look over the list and work with anybody that's interested.
Okay, thank you, Mr. Smith, and thank you, Madam Chair. Those were all my questions.
Okay, Representative Neighbor.
Thank you, Madam Chair. My first question is for Mr. Klump. And my question is, are most of these charges done or charged when these kids are juveniles, or are they ranked as adults in the court hearings? And the reason I ask that is that as a juvenile, usually those are expunged or removed later on when they get to be 18. If they are charged as an adult, and let's say it's a murder case, they're not let go if they're charged as an adult. So I need some definition there.
Thank you for the question. That's a very good question. If you look at subsection K, the addition on page 4 towards the bottom, starting on line 34, the two subsections that are allowed to be exempted are A1 and A2, and then you've got AA, which is another item altogether, but the criminal activity is in A1 or A2. And if you go back to page 1 and you look at A1, that list contained in A1 is primarily, it's all adult convictions. And if you look at A2, you're looking at the juvenile adjudications. And so the list is slightly different in those two areas, but the list of crimes committed as a juvenile are in A2. The list of crimes that are committed as an adult are in A1. I believe that's accurate. The revisor certainly will correct me if I'm wrong on that.
May I ask another question, Madam Chair? So these kids are charged, and now we're saying that in a situation where a family has taken them and adopted them and given them guidance and are willing to work with them, which is a hard area to work with, what do you do when you tell this child you don't have a home anymore? Where do they go? And what does society offer them for stability? Because if they're put out on the street and they don't have support, we're not doing them any favors. So how would you address that?
Madam Chair, the second time, was that directed at me or someone else?
Yes, I'm sorry, I should have said your name.
Oh, okay. I'm sorry, I just wasn't sure. And this is Ed Klump. You know, I don't have a response to that because I think you need people in the field that are and we got plenty of them testifying today that are familiar with all those annuities and that. But you know, it's not the residential kids being placed in foster care that concern us as much as it is the breadth of the proposal that not only includes foster homes, but it also includes the adults in other child care facilities that are charged with taking care of children who, under this bill, could be exempted from crimes against children, that have been convicted of crimes against children. I think the issue with foster care, and we've worked very hard over the last few years on a lot of foster care issues that affect law enforcement. Those are very challenging. And I think those are the areas where reasonable exemptions can be found and be made, that will allow these children to be in good foster care homes, such as been talked about in the testimony from the proponents. But to do that in a way that also allows for so much more to be done than beyond that, is where we think the bill has problems.
So if it were clarified from the past representative that asked the question, and it was corrected, so daycares and those facilities were taken out, and this had to do with foster care only, and there were people to come to the table and look at the options that, or the charges that you presented to us, would this be something that you believe could be worked on and worked through?
Yes, I do believe there's room to, make those kind of adjustments. And I think there's three just very broad general areas. One is what kind of child care facility are we applying these exemptions to, or they are eligible for these exemptions? I think, our criminal laws are divided into severity levels with, the very low number of severity level is a very high level crime. There could be a separation that way. There could be a distinction between crimes that are committed against children versus other crimes. This list of crimes that's included in this bill is literally every crime that has been used to assure safety of people in child care facilities. And we would agree that there's some of those that would be very, we'd be comfortable with exempting with the proper review. But there's others that are so egregious and so harmful to children that to allow that type of person to be providing care or volunteering in the care of children is very troubling to us.
Thank you, Madam Chair. I'll ask the rest of my questions with a phone call. Thank you, Madam Chair.
I've got a question for Rachel. And I'm thinking about these kids that are in homes together that maybe a month before they turn 18. And I'm just wondering, in foster care, what kind of assessment is done to make sure that they're not a safety risk at that point too? I mean, there's nothing about their 18th birthday that changes everything.
Right. Thank you so much for that question, Chairwoman Kincannon. I think it is important in this conversation to address the issue of safety assessment in child welfare. I appreciate the conversation about a criminal justice approach to safety, which normally looks at recidivism as a key component of a risk assessment. When we're looking at recidivism risk for a person potentially who has not had a criminal history charge for 10 or 15 years, I think the risk assessment sort of speaks for itself. So when we look at safety, we have to look at it from a child welfare lens and recognize that Kansas is one of the strongest states for child safety in the country. We also have to recognize that we make safety recommendations every day for 7,000 children, for all of their caregivers to determine when a child is safe to return home, for all of their caregivers who are temporarily watching them out of the home. And there are specific guidelines set up for safety monitoring for children that are extraordinarily different than a risk assessment in the criminal mindset. And so we would want to definitely look at safety from the assessment of, is this child able to be safe from a child welfare perspective? rather than particularly get too caught up in whether a risk assessment that might have been relevant 15 or 20 years before can provide us any current information. As to the juveniles, I think if there is a safety issue in the home before an adoption, then we would have tried to address that before rather than after. So we wouldn't have a different safety assessment for two youth who are sharing the home before we would finalize permanency. If they weren't safe together before that, they wouldn't be safe together after that. So that's how I'd answer that, and appreciate the leeway in responding to the question.
Thanks for that response. That's exactly what I was asking about. Let's see. Representative Penn.
Thank you, Madam Chair. I guess my question to both the sheriff's organizations and Ms. Marsh, I guess Ms. Marsh, you can grab it for me first on the heels of Madam Chair. We keep hearing this vacillation between what constitutes a teenager and what constitutes a child. And like you said, from the law enforcement perspective, what constitutes an adult. What is the age that you would say is a child for Ms. Marsh?
Thank you for the question. It's an important one. And of course, never a simple answer, but in juvenile justice code, there is a simple answer. And that is if you're a child or a juvenile is how they define it. Well, until you're 18. Once you're 18, you're an adult. It's a very clear and bright line. Developmentally, there is a difference between children and adolescents, young adults and adults. But from a legal perspective, as well as from the Child in Need of Care Code, there is a line between an 18-year-old and an adult.
Okay, so your answer is that 18 is an adult. You have people that have these charges against them. You know that sexual offenses have a higher recidivism rate, but yet you're a proponent saying that it's necessary and proper because I don't know what the stressor is. You don't have enough individuals to open up their homes and take on the children and the adult, and you don't want to split those families or the bonds that they've already created, if I understand your argument correctly. The question that I have is it okay to have adults who have those types of charges around them, on them, around children in the home?
I would almost appreciate that question, and I think it's important to clarify. I would not anticipate almost any circumstance where the Secretary of DCF would exercise her discretion around a sexual history. Sexual history is a unique category, and I think we could look at tightening this.
I would expand that to drugs. I would expand that to violence against women. I would expand that to the whole gamut, violence against children for that matter as well. The next question I have for you is there anything in your understanding of how this one is currently written, the bill is currently written, if someone were to be in a child care worker and have the secretary as the single point of failure on this decision-making process without a panel or any other eyes on it, if they had their record or they had this waiver given, they got into that particular line of work, and they could rise through the ranks to presumably be the DCF secretary because this wouldn't be held against them. Is that something that has the potential as well?
Thank you for the question. Sometimes I have trouble with my lawyer side, and I want to answer like a lawyer, and I'm really trying not to. I think it's theoretically possible, but I don't see it as realistic. What we're looking at, I think the core purpose of this is whether a kinship provider, a grandparent, an aunt or an uncle, who may have had a minor infraction with the law from 20 years ago, whether they can be licensed as foster parents or whether we would only place a child with them but not license the home. And also the other population of youth with the two foster youth, as the stories that you heard earlier. So if we need to exclude the congregate care setting, I think that makes sense. But theoretically, sure, I suppose it would be theoretically possible under the language of the laws.
Thank you. I appreciate it. I have a quick question, Madam Chair, my last one, if I may, please, for Mr. Klump or Mr. Greg Smith, please. Quick question, gentlemen. You said that you would be willing to set this into both a panel, impanelment to do this waiver and actually put eyes on it, and there would be certain types of offenses that you would think that would rise, that you'd be okay with. Can you email the chairwoman with those ideas that you have so she can distribute it to the group so we can have a better understanding of what it is that you're proposing there, who should be on said panel, and what types of offenses would fall within the bailiwick? Thank you, Madam Chair.
Well, this Ed Klump. I'll let Greg answer the panel question because that was in his testimony, not in ours. But in regards to the level of crimes, I would just like to say that if we have crimes on this list that we would expect the secretary would never approve a waiver for, then why do we include them on the list? If there's a belief that the secretary would never approve a waiver for a sex crime, then why do we include it? And as far as I think part of your question was beyond just the oversight panel, but this list of statutes is almost every criminal law in the books. And to sit down and go through and say, well, this one's okay, this one's not okay, on a charge by charge basis, statute by statute basis, would be very difficult. But I think we could convey kind of a general idea of where the bulk of the concern lies.
Yeah, and as far as the panel goes, I used basically that was just an example, a reference that even in the prison system, the Secretary of Corrections has the authority to release a prisoner, say, that has a terminal illness. But even before that can be done, it has to go in front of a review board of several different people, some of which are even in the legislature, and they have to go over the whole case file and decide everything. So it's not just okay, this is a situation, and I think this is the best thing to do, and that one appointed, unelected person makes that decision, and that's our concern. Is it's just a tremendous amount of power to put in one person's hand.
Representative Ousley.
Thank you, Madam Chair, and thank you to all the conferees. This is hopefully a fruitful discussion. I've got a number of follow-up questions, if I may. First one would be just clarification from the reviser that currently there is no spot for opposition to an individual exception to voice their opinion as written in the bill today. Not necessarily a review board, as Mr. Smith is speaking of, but just if the secretary was to make an exception and there was a relative to that individual the exception was made for that thought that was a terrible idea, is there a spot other than just going directly to the secretary to voice that opinion?
Representative, since this bill, the only part that pertains to this new exemption is in subsection K. That subsection does not provide any option to appeal the secretary's exemption that they've granted, or any sort of formal process to voice an opinion on that exemption granted.
Thank you for that. And then my next one would be for Mr. Hendricks with DCF. The question was asked earlier, if we limited the scope of this to just youth and kinship placements, does DCF hold an opinion upon that, or does DCF feel like they need the child care workers in here also?
My apologies, I was muted. Thank you for that question. Again, I think we are open to suggestions and revisions that would make this meaningful and applicable to those who really need it. I think the whole congregate care thing can definitely be revisited. I also want to add that the intent was to write this specifically for foster care and DCF, as childcare is still licensed by KDHE, and the Secretary of DCF could not make an exception on behalf of KDHE. So, but yes, we're willing to definitely look at the congregate care piece and narrow this down if necessary.
Thank you for that clarification in the statement of intent, because that was how I understood the intent of this bill, was the direction it was heading also. And then to the statement or comment earlier, you know, that a risk assessment is a length of time, you know, after conviction, after your papers were served, whatnot. Would Mr. Smith or Mr. Klump comment on that? Would there be a length of time that somebody had been clean, so to say, that they would feel like an exception would be appropriate?
As I said, Klump, that was something I brought up, and I'll respond to that. I don't know if you can set a specific time in every circumstance, but I think there should be some type of a time frame that is considered not applicable. In other words, a person should demonstrate it to some degree a period of time where they have kept their life in order. One of the cases that was brought up by one of the proponents was, and maybe two of them, was a case that the conviction had been 20 years prior for a minor offense, both of them said. And certainly that's a reasonable time to add some credibility to the fact that the risk of danger is reduced. But I think those two have to be tied together: the seriousness of the offense and the length of time since the offender has completed their sentence.
Thank you for that response. And I agree. And thank you guys for bringing your concerns before the committee. The example that was given to us in our oversight committee this last interim was dealing directly with kinship placement, but I would like to think that we could make that applicable if we needed their services in a child care facility as well. So thank you, Madam Chair. Thank you, conferees.
Representative Wagoner.
Thank you, Madam Chairman. This would be to Mr. Hendricks from DCF. You know, we've had some good testimony from the families represented here, sort of the conundrum or the catch-22 they can get into with being foster care parents and with, you know, older teens. DCF making this sort of a priority for their own legislative group. Did DCF have other situations besides these specific foster care situations where this had become kind of an issue that you wish you had the power to present an exception to the normal rules?
Thank you for that question. This has been the most common, most prevalent issue brought forth to us relating to the prohibitive offenses and how it has been impeding to both permanency, adoption, and licensing of that nature. I believe each and every one of our providers has at least one impact story that they brought to us, or a situation, and several of our providers have several stories. So, I mean, this has been the focus that we've been looking at for 2 or 3 years on how we could try to address this.
If I could ask, so besides the foster care family situation, was there like a second place one or something that it had come up in group boarding homes, or I don't know, someplace else where it was a problem, you know, from DCF's perspective?
Oh, thank you for that clarification. The short answer on that would be no. I mean, it's the group boarding homes has not been nearly at the forefront as the specific family settings. And I think the intent of this is more definitely more directed at those family settings for permanency, for licensure, for adoption.
Thank you.
Further questions? Representative Helmer.
I'd just like to say something real quickly. I'll share something with you. My brother and sister, and I showed you the picture, but they adopted a little boy a few years ago, and he's 6 years old. His parents shook him, and when his brain swelled, they cut the top of his skull off, and he's about 6 years old, 7 years old now, and he is a hot mess. He has a lot of brain problems, but he's under control now, but he is really learning disabled, really emotionally disabled. And as he grows older, he's going to fit the bill on this. My brother and sister are older, and I don't know what's going to happen. They're sweet people, but this bill is going to help in some way. A lot of, coming from just retiring from school, a lot of older people adopt children. They have the heart, they have the love, and so that's what is adopting children a lot of times. And those children have been kicked around like bad dogs, and it's heartbreaking. Thank you, Madam Chairman.
Okay, committee, we're going to close the hearing then on House Bill 2149. And I just want to say thank you for the foster parents who were here and gave testimony, and the ones that have written in. I mean, it's obvious that there's a problem, that there's a heart-wrenching problem. And, you know, whether it's this bill or, you know, we need to amend this bill or look at something else, I think that we can certainly put some people together and figure out some way for you to continue to be able to help a young man in your case, but that still needs some guidance after that 18th birthday. And that's, you know, that's exactly what we're looking for. So I think we'll probably be having some further conversations on this bill, and appreciate anybody who's working on it if you want to contact me through my office. With that said, what are we doing tomorrow?